Have you ever come across TUPE, that's the Transfer of Undertakings regulations? These are regulations which cover the transfer of a business from one person to another, or indeed the transfer of a contract, for example catering, security, cleaning, from one party to another. If so, then this video I'm going to take a look and explain in plain English the key components of the TUPE regulations in Ireland. So stay tuned. Okay, TUPE is essentially the Transfer of Undertakings regulations in Ireland. They put into effect the Transfer of Undertakings Directive, which has come from Europe and covers the transfer of undertakings from one party to another. And the essential purpose is to protect the rights and entitlements of employees. So it protects employees in a transfer of undertaking situation. What is an undertaking? There is no one definition. There's no definition in any of the legislation about what an undertaking is. However, it is an economic entity and can be any one of a business, a part of a business, a school, a college, an educational institution, a charity, a local authority, a health board, trade association, trade union, or a semi-state or state body. TUPE law in Ireland, the relevant regulations is Statutory Instrument number 131 of 2003, that is the European Community's Protection of Employees on Transfer of Undertakings Regulations of 2003. Also of relevance is the Employees Provision of Information and Consultation Act of 2006, which spells out the obligations to consult and inform employees in a transfer of undertaking situation. In a nutshell, the rights and obligations in respect of employment contracts of the transferring business are transferred to the new business. So employees' terms and conditions stay the same. Employee and trade union contractual entitlements survive post-transfer, regardless of whether the purchasers are aware of these entitlements or not. The underlying philosophy is that if similar activities are continued in different hands, the identity of the undertaking remains, a transfer occurs, the employees follow the work, and protection is enjoyed by the employees. However, pension rights do not transfer, and TUPE does not arise where the transfer of a business is by way of a share sale. And that is because the undertaking or the business doesn't actually change hands in that situation. All that changes hands there is the ownership of the shares. So there must be a transfer of undertaking for TUPE regulations to apply. The key criterion in deciding whether there's a transfer within the meaning of the regulations or not is whether the activity is seen to be continuing, even with some differences, or even where all of the economic activity has not transferred. Therefore, transfer of part of a business is covered. A mere activity, however, as opposed to a part of an undertaking, is not covered. There's a lot of case law in Europe as to whether TUPE applies in particular circumstances or not. Each individual case should be looked at on its merits, and it should be decided then whether TUPE applies or not. Okay, as I was saying there before the interruption, can employees agree change before the transfer? Well, only if the change is an improvement in their terms and conditions. Regulation 9 of the regulations prevents any contracting out of an employee's rights. So the relevant statutory instrument, as I said, is 131 of 2003. If you want to actually look at these regulations yourself, there's not a whole lot in it, and you can Google that statutory instrument, take a look yourself. You'll get the statutory instrument on the Oireachtas or Irish Statute Book website. Regulation 4 deals with rights and obligations. 5 deals with dismissals and termination of employment. 6 deals with bankruptcy and insolvency. 7 deals with representation of the employees. 8 deals with consultation and provision of information to the employees. 9 deals with agreements, and 10 deals with complaints. In relation to complaints, the penalties for breach of Regulation 8, which is the consultation and information regulation, is up to 4 weeks remuneration for the employee. However, breach of other regulations can see an award of up to 2 years remuneration for the employee. There is a defence, the ETO defence, that's the economic, technical or organisational defence, which allows dismissal arising from the transfer of an undertaking, provided there is an ETO defence. So it's very similar to redundancy. The transferee, however, will be liable for redundancy payments. Does the employee have to transfer? No, but he's not entitled to redundancy and is deemed to have resigned. That's based on High Court decision a couple of years ago there. I think Symantec and Lyons or something like that was the name of the case. Not 100%. Don't rely on that, but that's what the High Court has held. So no, the employee does not have to move, but if he or she doesn't move, well then he's resigning and he's not entitled to redundancy. So service providers, TUPE arises a lot. I've come across in relation to contracts for the provision of services such as security, catering and cleaning. There are two scenarios. There's a first generation transfer and a second generation transfer. The first generation transfer is where a company might, for example, decide to contract out its catering, cleaning, security or whatever. Second contract or second generation transfer arises where there's a change of a service provider. So you may have a school or you may have an institution which has a catering facility, and they put the contract out to tender then after a year or two, and a new service provider comes on board. Does TUPE apply in these situations? Okay, it's not exactly straightforward, but you should nearly assume, I think, that if you're involved, you should nearly make provision for TUPE applying, because it's the most prudent, cautious way to approach it, I believe. So remember that TUPE applies to transfer of undertakings, not a transfer of a mere activity. However, the particular circumstances of each case will determine whether TUPE applies or not. What will be looked at will be questions like, have assets or resources transferred? Have employees transferred? In an asset-intensive undertaking, TUPE may not apply if it's only the employees who transfer and not assets, either tangible or intangible. In a labour-intensive undertaking, on the other hand, for example, security or cleaning, if the transferee refuses to accept the majority of employees, then TUPE will probably not apply. However, in a labour-intensive undertaking, if the majority of employees or employees do transfer, well then TUPE will apply. Problems really in a TUPE situation generally fall at the door of the transferee. So he needs to consider taking on new staff and the associated costs. He needs to ensure that the new staff taken on maintain the existing terms and conditions, and he's going to have to deal with any friction arising in the workplace where he may have a situation where the new employees coming in have better terms and conditions than his existing employees. Also, there may be costs associated with the transfer of employees, for example, the cost of carrying out redundancies if necessary. It's advisable, if possible, not always possible, to negotiate an indemnity if you're a transferee. In other words, you'd be looking for some form of comfort, some form of indemnity to cover any liabilities arising from the transfer. However, you may not get it. So if you're looking for or to tender for a TUPE contract, look closely at the terms and conditions of existing employees. Look at the length of service each of them has. Carry out an audit and raise queries. Check for any hidden liabilities, for example, claims from employees against the transferor. These claims may transfer to you with the TUPE transfer. And negotiate the best indemnity or indemnities you can to protect you against liabilities post-transfer. Again, this may not be possible. It may be just the fact that you are buying or taking over a business and it's a question of, look, here's the deal, take it or leave it, we're not giving you an indemnity. It also may be the case where you are winning or have won a contract in a school or in some other institution or in a factory or whatever, and nobody's going to give you an indemnity, neither the factory owner or the school owner, nor the existing holder of the contract. My name is Gorry. I'm a solicitor in Enfield and County Meath. You can get more information about employment law and about TUPE, transfer of undertakings, cases, case law, about changing service providers and so on at that website there, employmentrightsireland.com. If you think this video is useful, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube